Good morning, everybody. Thank you for joining us this morning. My name is Amber Hines with Ashburn, and I want to thank you for joining us for this webinar on understanding the type of assets that your clients own and how you can plan with them. If you're interested in a copy of the handouts or the slides from today's webinar, feel free to access those in the handout section of the dashboard. Also, if you have questions or comments throughout the webinar, feel free to type those into the questions tab as well, and we'd be happy to answer those. Again, my name is Amber Hines. I'm the initial founder of Ashburn, and we created this company to really specialize in Medicaid compliant annuities offered from A-rated insurance carriers. And I'm very happy to have attorney Mark Munson with me today. Mark is a certified elder law attorney and practices primarily in Wisconsin, but he is also licensed to practice law in Illinois as well as South Dakota as well. Mark, if you want to just say hi, feel free.
Welcome, everyone, and thank you for joining us today, and where we talk about our clients' assets and what we can do with planning from them from a Medicaid context.
Thank you. So we have a lot of information to go through today, so we're going to go somewhat quick, but like I said, feel free to follow along on the slides that are in the handout section or print these off if you wish. So when we talk about Medicaid planning, we're talking about either spending down a client's assets or otherwise helping them to protect their assets so that he or she can meet the financial criteria for Medicaid qualification, or we can get them down to the allowable asset and income limitations for Medicaid qualification purposes. When we're talking about Medicaid planning, we can divide the planning into two different types. We have pre-crisis planning as well as crisis planning. Mark is going to take us through crisis planning, and then I'm going to talk about the crisis planning aspect of it.
Yep. So with pre-crisis planning, the goal is pretty straightforward, as we'll show in later slides, to qualify for Medicaid from the financial requirements. Generally speaking, your assets have to be very, very limited. So from a pre-planning standpoint, the goal is to use the time that you have, which means that long-term care is not imminent, and by that we mean 5 years or more. That's kind of the planning horizon, and the idea is really to move assets out of the client's name, and so that they reduce their assets. So if they do need long-term care in the future, they're already at a level where they may be qualified for Medicaid or closer to qualifying for Medicaid. The more assets you have at a crisis point, which is what Amber will cover, the more difficult it is. So, you know what? In pre-crisis planning, you're trying to do one of two things, which is either reducing assets or acquiring long-term care insurance, so that there is an insurance product available to cover those types of costs, because Medicare generally does not do that. So pre-crisis planning, very, very, very simple. There's insurance planning, long-term care insurance. There's legal planning, which means getting assets out of your name. And that, in a nutshell, is pre-crisis planning.
Great. And then on the side of crisis planning, we're talking about a client that is already in need of assistance with activities of daily living, or we anticipate them needing assistance with ADLs very soon. So in a crisis planning scenario, we do not have the 5 years or the 5-year look back period to wait out. So we're in crisis mode at that point, and we're using various planning strategies to basically convert countable assets for Medicaid planning purposes into non-countable or exempt assets so that the person will qualify for Medicaid as quickly as possible. Crisis planning can include legal planning, insurance planning, or a combination of the two. When we talk about our planning goals for Medicaid in a pre-crisis planning mode, like Mark talked about, we are trying to transfer as many resources or assets out of the person's name as possible into an irrevocable Medicaid trust or to individuals directly. In a crisis planning scenario, we're trying to convert countable assets, countable resources into non-countable or exempt resources in the most cost-effective, tax-efficient way. And then our third goal would always be to minimize or avoid estate recovery if possible.
Right. And anytime you are going to implicate Medicaid system and Medicaid benefits, you always want to be mindful of estate recovery, because it's going to play a role anytime there's again, qualification for Medicaid. So this next slide is the basic Medicaid eligibility requirements. There's non-financial and financial. We don't spend a lot of time on the non-financial because it's pretty straightforward. You know, either a U.S. citizen or a qualified alien, and then you either need to be age 65, disabled, or legally blind. And so those are the non-financial requirements. On the financial side, again, Medicaid is a means-tested program. We look at people's means. What are means? That those are your resources, your assets, and income. So the next slide details for us some of the rules that are in place for Medicaid. So if there's a single individual, there's an income limitation. In order to qualify for Medicaid, the general rule is that your income has to be less than the cost of care. And of course, for most seniors who are in a nursing home or even assisted living, they will meet that general requirement. There are some states where there's an income cap, meaning that if your income is greater than this level, you don't qualify for Medicaid, but that can be cured by doing a qualified income trust, that's the QIT, or a Miller trust, so that your income can go into the trust so it's not counted, so you can get below the cap. And then for a single person, the person who's in the nursing home, the asset limit as a general rule is $2,000. There are some states that have deviated from that, but the general rule is you get $2,000. And then for a married couple, from the income standpoint, we've got the again, the spouse who's in the nursing home, his or her income must be less than the cost of care, so it's the same standard. Again, we have the exception for the income cap states. And then the community spouse, the spouse who's not in the nursing home, who we are not looking to get qualified for Medicaid benefits, the community spouse, his or her income can be unlimited, but if his or her income is below a certain number, every state has a different number, it's called the MIMNA, or Minimum Maintenance Monthly Needs Allowance. If it's less than that, the community spouse may very well be able to get income from the nursing home spouse or the institutionalized spouse. Again, in a married couple situation, we've got the nursing home spouse or the Medicaid spouse being able to allow to have $2,000 in his or her name. The community spouse, the spouse who's still living in the community, that spouse, as again, very, very general rules here, because states will vary. But the general rule is that the community spouse is going to be able to keep 1/2 of all non-exempt assets up to a certain amount. And as you can see on the slide, that certain amount generally is $128,640. So then one of the things you have to do and we're really talking about crisis cases right now and qualification for crisis cases. One of the important steps is to identify what assets are countable and not exempt for purposes of qualifying for Medicaid, and then also determining what assets are exempt and not countable. So assets that are again countable or not exempt, as we just said, they work towards the Medicaid asset limitations that we just talked about. If they are protected, exempt, or non-countable, all meaning the same thing, they're not. These assets are not barriers, so to speak, to qualifying for Medicaid. You can have these assets and qualify for Medicaid. That doesn't not necessarily mean that these assets would not be subject to estate recovery. They may very well be subject to estate recovery. So it's important to always remember estate recovery and the distinction that just because you're qualified and eligible doesn't mean that the assets that allow you to be qualified and eligible would not be subject to estate recovery. They very well may be.
Okay, so when we're talking about countable or non-exempt assets, these are really any type of assets that have cash value or surrender value that can be used to help pay for somebody's care. So we're talking about cash, certificates of deposit, checking accounts, savings accounts, investment accounts, permanent life insurance policies, which we'll talk more about. So this does not include term policies, non-qualified deferred annuities, IRAs in some states, which we'll talk more about, and then non-homestead real estate, so any kind of real estate outside of the primary residence, boats, RVs, and then a catch-all is really anything else that is not considered to be an exempt resource in your state.
So on the exempt asset side, the home, it's odd to think about your home as being an exempt asset, but technically, as long as there's an expressed intent to return home, the home is not going to prevent somebody from being qualified for Medicaid. But as we've noted on the slide, you have to be careful of the state Medicaid agency being able to put a lien on the home. And this generally occurs if it's determined by medical attending medical personnel that the person, even though they express an intent to go home, or their agent under a power of attorney or guardian does that, it's not realistic and it's not probable, and then a lien can be put on the home. An automobile, generally of unlimited value, but again that varies, is exempt asset. Term life insurance policies, there's no cash value to a term policy, so it doesn't count towards the $2,000 asset limit. It can't. But as we've noted on the slide, you have to be mindful of estate recovery, and if a state has enacted expanded estate recovery provisions, particularly the death benefit proceeds from a term life insurance policy may be reachable by your state's estate recovery program. Household goods and personal property are also exempt. An irrevocable or prepaid funeral arrangement is exempt. And then, as we will show in some future slides, IRAs, both whether it's the Medicaid applicant or if married, his or her spouse may also be exempt, but we caution again that just because they're exempt for Medicaid qualification and receiving Medicaid benefits, that they still may be subject to, those assets may be subject to estate recovery at death. And again, this is particularly the case if your state has enacted expanded estate recovery provisions.
Okay, great. So we're going to start out with some basic information as far as different types of bank deposits. This may include savings accounts, checking accounts, or CDs. For Medicaid planning purposes, money that is held jointly, for example, with a child in a bank, is all going to be considered the asset of the Medicaid applicant or the spouse if they're the joint owner on the contract. And it's really up to the Medicaid applicant to prove that the funds, if they're in a joint account, do not belong to the Medicaid applicant. So that can be a tricky situation if you don't have statements that are showing that the child actually made a deposit into a joint bank account. So that's something to be aware of. And then a CD is just like a savings certificate with a fixed maturity date and a specified fixed rate of interest that can really be issued for any amount of money aside from the minimum investment requirements. And a CD is going to restrict access to the account a little bit more than if the money was just sitting in a savings account. So a savings account as well as a CD are both going to be insured by the FDIC or the National Credit Union Association up to $250,000 per individual. So if we go to withdraw money from a CD before the maturity date, there is going to be an early withdrawal penalty, which is usually the interest that would have been earned on the contract to break the CD early. So that's not really that difficult to do when we're talking about planning with either a CD, a savings, or a checking account. These are all accounts that are pretty liquid that we can initiate pre-crisis planning with or crisis Medicaid planning with. So as long as the CD or the savings account is not funded with pre-tax dollars or IRA dollars that we have to be aware of, the account is pretty easy to transfer into an irrevocable Medicaid trust or spend down with pretty minimal tax consequences or early withdrawal penalties. When we're talking about an IRA, or qualified accounts, an IRA is one type of qualified account that allows the individual to maintain the account under special rules that allow the owner to avoid income tax until retirement age. So tax laws will impose an early withdrawal penalty for withdrawing money from an IRA earlier than 59 and a half, but that does not prevent Medicaid from considering that to be a countable asset in certain states. A 401k and a 403b are like an IRA, but they are going to be administered by the individual's employer versus by the individual directly. But like an IRA, these accounts are also going to incur an early withdrawal penalty if you take money from those accounts before 59 and a half and are still going to be considered countable in certain states for Medicaid planning purposes. A pension fund is another type of qualified retirement account, but this is only going to be countable as an asset for Medicaid planning purposes if the owner of the pension fund has the right to remove the funds as a lump sum. If the pension is already in payout status or the owner is only entitled to income from the pension, that it then is only going to be considered income and is not a countable asset for Medicaid planning purposes. So really you have to look at, does the person have the ability to access that money out of a pension, or is it already in income paying mode? So there's many different types of qualified or pre-tax accounts. They can include 401ks, 457s, a thrift savings plan, a 403b, a SEP plan, a simple plan, and it really just depends on where the individual worked. If they have a 403B, a lot of teachers and state employees will have a 403B. So all of these are going to be considered pre-tax accounts that we have to be aware of and look at whether your state is going to consider these to be a countable asset or not. So the underlying investment of a qualified account can consist of many different investments. So it could be stocks, bonds, mutual funds, annuities, or a CD. But regardless of the underlying investment of the qualified account, these are all pre-tax accounts, meaning that the money has never been taxed before. So once the money is withdrawn or ownership is changed, the account is annuitized, then tax consequences are going to be triggered at the point that the client makes a withdrawal, or they change ownership on the account, or they elect to annuitize the retirement account. Changing ownership of a qualified account from spouse to spouse or transferring into a trust will cause an immediate taxable event. Important ages to know for qualified accounts, as I mentioned, 59.5 is an age that you should be aware of when you're looking at whether the person will be imposed with a 10% early withdrawal penalty. So if they try taking money from a qualified account before 59.5, there will be a 10% early withdrawal penalty unless they fall under one of the certain exceptions to the penalty. So if they are disabled or if they are receiving systematic equal payments under the qualified account, then there are certain exceptions that will avoid the early withdrawal penalty. But then also at age 72, this is going to be the maximum age that a person can reach before they have to take required minimum distributions or a certain amount out of any of their pre-tax retirement accounts. So this does apply to IRAs, 401ks, 403Bs, any type of account that has not been taxed before. We will have to start taking money out of the account at 72 years of age. That was recently changed under the Secure Act. It used to be 70.5 that the person had to start taking their required minimum distribution. When we talk about qualified accounts and Medicaid planning, each state is different as far as IRAs or how qualified accounts are going to be treated for Medicaid planning purposes. States are going to take one of the following three positions. They can either completely exempt the IRA and consider the account to be non-countable altogether. They can consider the IRA to be exempt if the IRA owner is receiving their required minimum distribution or systematic payments out of the contract. So in that case, they're going to consider the account value to be exempt, but the income is going to be countable for Medicaid purposes. And then the third option is that the state is going to completely count the IRA as an available resource or an available asset that needs to be spent down before the person is eligible to receive Medicaid benefits. It may be different for the Medicaid applicant or the institutionalized spouse versus the community spouse, and you'll see that in the next couple of slides. And you can always check with us if you're unsure as to how your state treats qualified accounts. Here you're seeing a map of states that consider the institutionalized spouse or the Medicaid applicant's retirement accounts to be countable versus exempt. So the states that are in orange on the screen are states that consider the IRA, the qualified account, to be an exempt resource, either completely exempt or exempt if the person is receiving their RMD. The states that you're seeing in white are all states that consider the IRA to be a countable resource. So like you can see here, most of the states do consider the Medicaid applicant's retirement account to be an asset that needs to be spent down or converted into a non-countable asset before the person is eligible. When we have an institutionalized person that has a retirement account that is countable and we're in a crisis planning mode, there are several different options that we can use to convert the institutionalized spouse's qualified account. So the first option would be to liquidate the Medicaid applicant's qualified account and transfer the net proceeds or pay all the taxes on the institutionalized spouse's qualified account and shift the net proceeds over to the community spouse. So in that case, because we can't change ownership without paying taxes, the spouse that is institutionalized is going to pay all of the taxes up front, and then the net amount is what's going to be received by the community spouse. The second option would be to convert the institutionalized spouse's qualified account into an IRA Medicaid compliant annuity. The third option is to use name on the check rule. Option number 2 and option 3 are very similar, other than whose name is going to be on the check when we annuitize the institutionalized spouse's qualified account. If we use name on the check rule, we're going to have the insurance company make the check payable to the spouse that is remaining at home, so that that income that's generated from the annuity is considered to be income that belongs to the well spouse and not the institutionalized person. The fourth option would be to implement an in-marriage quadro, which we've done other webinars on. If you have questions about that, feel free to either reach out or watch another webinar recording. This is a map here that is showing you the name on the check rule and which states we have favorable decisions in versus which states there are unfavorable decisions. And when we say unfavorable decisions, basically that means that the income, when we tried to shift the income from the annuity over to the community spouse, it was deemed to belong to the person in the facility. So in that case, depending on the size of the qualified account, it probably would have been better to pay the taxes and shift the qualified net proceeds over to the community spouse in states that you're seeing in black that do not recognize name on the check rule. And then the states that you are seeing in white, we've had mixed outcomes. In some counties, the name on the check rule was favorable, and in other counties it was not. This map is showing you in-marriage quadro and which states in-marriage quadro works in versus states that do not recognize in-marriage quadro, meaning that the spouses would likely need to get divorced in order to transfer a qualified account from the institutionalized person over to the community spouse. This map is showing you the states that consider the community spouse's retirement accounts to be countable or exempt. So again, the states that are in orange are going to be states that consider the community spouse's qualified accounts to be exempt. You may notice that Wisconsin and Pennsylvania are two states that consider the community spouse's qualified account to be exempt, but they count the institutionalized spouse's IRA account. So like I said, some states do one thing for the Medicaid applicant's qualified account and they do another for the community spouse's qualified account. And then the states that are in white are, again, states that consider the qualified account to be a countable resource. When we have a community spouse that has a countable retirement account in a crisis Medicaid planning scenario, we can either keep the qualified account as part of the community spouse resource allowance. If it's a smaller IRA account or qualified account that is within the SESRA limits, then they can just keep that and not have to spend it down. But if it's an IRA that would exceed what the community spouse resource allowance is, then we would be most likely looking at converting the community spouse's qualified account into an IRA Medicaid compliant annuity. When we're looking at long-term care planning with qualified accounts, we already said that changing ownership of a qualified account from spouse to spouse or transferring a qualified account into a trust will cause a taxable event, which means that pre-crisis planning or trying to transfer qualified accounts out of the client's name is going to be very difficult to do without paying taxes. So we can't change ownership and we can't transfer that account into a trust and start the 5-year look back period without paying taxes. So pre-crisis planning is going to be very difficult to do with qualified monies. Whereas, go ahead.
And just with, you know, just to add to that, and it is difficult to do pre-crisis planning with qualified money. If you have a client who is, you know, relatively healthy and motivated to try to do some Medicaid planning, it may be possible, it may be worthwhile to look at systematically year after year taking some money out of the retirement account, even if it's not needed. And yes, you're going to pay some tax on that, but tax usually can't be avoided, whether it's by the individual who owns the account, his or her spouse, or their children. So you're always going to be facing a tax at some point, either present or later. And it may be worthwhile to systematically, year after year, look to reduce the retirement account by taking money out. And then once it's out of the IRA, yes, it's subject to its income, subject to income tax, but the balance that would be left over after paying the tax, that could be then transferred to a trust. So that is some planning that could be looked at with a client on the pre-crisis side with qualified money.
Okay, great. And then on the crisis planning side of things, we just talked about there are several options, whether the qualified account is owned in the name of the Medicaid applicant or the community spouse. We talked about those on the previous slides. When we're looking at funding an IRA MCA, we would either use a direct trustee to trustee transfer, where the company that's issuing the IRA MCA would obtain the money directly from the current IRA custodian, or the second option would be to use a 60-day rollover, where the client is going to request a liquidation check without withholding taxes, and we would reinvest that money into the IRA MCA within a 60-day time frame. So either one of those options would be available if we are dealing with qualified accounts that we're trying to get into an income format that would qualify for Medicaid planning purposes. Roth IRA accounts are kind of the opposite of a traditional IRA. These accounts are going to be funded with post-tax income, and when the money is withdrawn from a Roth account, it is going to be tax-free. So usually the account owner must hold on to a Roth IRA for at least 5 years and be at least 59 and a half before they can tap into the earnings on a tax-free and penalty-free basis, but they can always get the initial contributions out of the account without paying taxes because they used after-tax dollars to fund the Roth account from the beginning. So long-term care planning with Roth accounts, because we're using after-tax dollars to invest in a Roth account, pre-crisis planning is not going to be difficult to initiate with Roth accounts. We will lose the tax-free growth if the account is retitled into a trust. And then crisis planning is also going to be pretty easy to do with a Roth account if we need to, because again, it's not going to be a pre-tax account that we have to be concerned about large tax consequences if we were to do crisis planning with these accounts. Securities are going to be any type of stocks, bonds, treasury bills, stock options, futures, mutual funds, money market funds, or promissory notes. Securities are going to be based on the traded value of the security. There are some securities that do not have any market value, and in that case, the account is not going to be considered an available resource for Medicaid planning purposes if we can't actually sell a security that the client owns. It's always important to review the client's investment statements. By looking at the investment statement, we will find out what type of account the client owns, and there's several different types of sub accounts that can be under one investment statement. So there can be IRAs or stocks and bonds that are purchased with after-tax dollars versus pre-tax dollars. So if we review the statement, this is going to tell us who actually owns what accounts. So if it's a husband and wife, who owns the accounts, and then also which accounts are retirement accounts versus non-retirement accounts. And sometimes that can be confusing to clients. So I always look at the statement to determine what they actually own before I would be recommending certain avenues to spend on those resources. Securities are going to be pretty easy to initiate pre-crisis or crisis planning with. And like I said, as long as the account is not funded with qualified dollars, the account can pretty easily be transferred into an irrevocable Medicaid trust through an in-kind transfer, or they can be spent down with minimal tax consequences. Now we'll move on to annuities. So there's several different types of annuity contracts, but generally they're going to fall into two different camps, qualified and non-qualified. A qualified annuity is going to be an annuity that is purchased with pre-tax dollars, and the distributions are going to be taxable income. If you withdraw money from a qualified annuity before age 59 and a half, there's the 10% penalty, and the person must start taking their required minimum distributions when they turn age 72. So this is going to be the same type of rules that apply to a 401k, a 403b, or an IRA. So a qualified annuity is a pre-tax account that has not been taxed before. Whereas a non-qualified annuity is going to be an annuity that is initially funded with after-tax dollars, but the growth or the earnings are going to be tax deferred. So this is going to be a mix of taxable income and non-taxable income when the contract is annuitized. With a non-qualified annuity, there are not any restrictions on taking money out before the person is 59 and a half, and they don't have to start taking an RMD at age 72. So these accounts can be pretty easily moved into an irrevocable Medicaid trust, but we do want to be mindful of any tax consequences if the insurance company that is holding on to the non-qualified annuity will not honor the transfer into a trust. There's two main types of annuities. The first is a deferred annuity, which has an accumulation period, meaning from the time that the money is invested into a deferred annuity, it's going to grow for a certain number of years. And so there is a cash surrender value or a lump sum value associated to a deferred annuity. There may potentially be early withdrawal or surrender penalties if the client wants to receive the money back from a deferred annuity earlier than what was initially agreed upon with the insurance companies. The 1035 exchange, which we'll talk more about, may help with any deferred taxable income that has grown within a deferred annuity. whereas an immediate annuity does not have any accumulation period. It is only going to be considered income once that contract is considered to be in force or annuitized. So the income payments from an immediate annuity must start within 1 year of the immediate annuity being purchased. So if I purchase an annuity today, I can't have the immediate annuity not pay out for another 20 years. The first payment must start within 1 year of the contract effective date. And either types of these annuities, a deferred or an immediate annuity, can be funded with qualified dollars like we talked about on the last slide, or they can be purchased with post-tax or non-qualified money. Not all immediate annuities are considered to be Medicaid compliant. So once an annuity is annuitized or converted from a lump sum of cash into an irrevocable income stream, is no longer considered an asset for Medicaid planning purposes because there's no longer cash value that's associated to an immediate annuity. But that doesn't necessarily mean that Medicaid is just going to consider that immediate annuity to be income. There's a lot of different things that we need to look at when we are looking at an immediate annuity that a client already owns to determine how Medicaid is going to consider that immediate annuity. So we have to look at when the annuity was purchased. Was it purchased pre-Deficit Reduction Act of 2005, or was it after the DRA? We also need to look at, was the annuity purchased with pre-tax or IRA dollars or post-tax dollars, because annuities that are retirement annuities are treated differently than post-tax dollar annuities under the DRA. And then also we need to consider whether the annuity is assignable or whether it can be purchased by a company like J.G. Wentworth or Peachtree, companies that go out and actively purchase immediate annuities for a lump sum of cash. And then, go ahead, Mark.
Sure. So when you're dealing with money that's typically non-exempt money, and what you're trying to do is to get that money converted from an asset to an income. You can do that by converting, let's just say it's money in a bank account, such as a CD, as Amber had talked about earlier, or it's investments in a brokerage account, stocks, bonds, or mutual funds. Those are assets that could present barriers to qualifying for Medicaid. And so in a crisis case, you're often looking to convert non-exempt assets to a stream of income, and one way to do that is to purchase a Medicaid compliant annuity. Now this will be an immediate annuity, as Amber talked about earlier, and then there are a series of requirements for an annuity to be Medicaid compliant under the Deficit Reduction Act. So one is that the annuity has to be irrevocable. The client can't, say, oh, well, I've changed my mind. It's no longer a stream of income. I'm going to have it as a lump sum asset. So you can't do that. The non-assignable portion, that again gets to the comment that Amber made just on the previous slide, that this contract is prevented from being purchased on the secondary market. It's not assignable, it's not transferable, it's not saleable, it's not negotiable. It's just, it is what it is. Actuarially sound means for the person who's the annuitant, that's the person who we're paying this out to, or whose life is the measuring life for the annuity contract, it has to be actuarially sound, meaning that it cannot exceed that person's life expectancy. And it's either going to have to be the applicant's spouse or the community spouse. Equal payments, meaning we can't have a balloon payment. We can't have where it's front loaded, where payments in the front are bigger than payments in the back. They have to be equal payments over the term of the annuity. And then lastly, you have to name the state as a beneficiary. There's an asterisk there because there are some exceptions. The surviving spouse can be named ahead of the state, as can a minor child. There are certain exceptions to when a beneficiary can be named before the state as the beneficiary of a Medicaid compliant annuity, but there are not many.
Mm-hmm. Yeah, it has to be a minor or a disabled child that can be, or a community spouse can also be named before the state.
Right. Or even an institutionalized spouse, but which may or may not make sense.
Mm-hmm. Okay, so now if we move on to life insurance, the cash value or the cash surrender value of a life insurance policy is the amount that has been saved inside of the policy. Some of the cash value is going to be part of the premiums that have been paid for the policy, and some is going to consist of interest. Group policies do not have any cash surrender value for the owner, so those would not be countable for Medicaid qualification purposes. Only whole life insurance, universal life, and permanent type of life insurance policies are going to be considered countable for Medicaid because they have a cash surrender value that is growing within the policy. Term life policies don't have any cash surrender value, so these policies are not going to be countable for Medicaid qualification purposes. And like we talked about, you'll want to be mindful of any estate recovery issues on a term life policy. The two different types of permanent life insurance are whole life and universal life. These are similar, other than a whole life policy is going to offer more consistent growth and premium amounts that would be paid for whole life, versus universal has more diversity in the amount of the premium payments that would be paid on a universal life contract. Long-term care planning with life insurance, pre-crisis planning, we can transfer ownership of the policy into an irrevocable Medicaid trust, or we can transfer ownership to individuals directly. If we're looking at crisis planning for a whole life or universal life policy, and we are trying to reduce the cash value of that contract and qualify for Medicaid, we can transfer ownership to a trust or to individuals directly. That is going to incur a penalty period for Medicaid planning purposes, but it is an option that we can do. We can also take a loan against the policy to reduce the cash value. We can liquidate or surrender the policy. And then finally, we can consider proceeding with a 1035 tax-free exchange into a Medicaid compliant annuity. So a 1035 exchange is a provision in the tax code that allows the policy owner of a life insurance policy, an endowment, or an annuity policy to exchange their existing contract for a new policy without having to pay taxes when they exchange for a new type of policy. So a 1035 exchange can take place between two life insurance policies, between two non-qualified annuities, or an individual can transfer their life insurance policy, the cash value, into a non-qualified annuity. The only stipulation is that a non-qualified annuity cannot be exchanged for a life insurance policy. So that is something to be aware of there with the 1035 exchange. Under a 1035 exchange, the money must be transferred directly from one custodian to the other, or from one insurance company to another. the contract owner cannot take possession of the funds from the policy. It has to be done between the two custodians. Also, the owner of the existing annuity or life insurance policy has to match the new owner of the new contract that would be purchased. So for example, we can't have an annuity that is owned by Joe Sample and have him purchase a new contract that is jointly owned with his wife. It has to be the same owner of the old policy to the new policy. The Pension Protection Act modified the 1035 exchange section of the tax code, which allows for life insurance policies or non-qualified annuities to be converted tax-free into either traditional long-term care insurance policies or a hybrid long-term care insurance policy. So the Pension Protection Act allows clients to withdraw cash value from life insurance or from an existing annuity tax-free in order to buy long-term care insurance. It also allows for a client to completely exchange an existing annuity for a long-term care policy on a tax-free basis. And we can access money from certain types of annuities and life insurance to pay for a hybrid long-term care insurance policy under the Pension Protection Act as well. So most non-qualified annuities and life insurance can be transferred into an irrevocable Medicaid trust without triggering tax consequences. If this is the case, then pre-crisis planning can be accomplished pretty easily. In a crisis Medicaid scenario, we can initiate a 1035 exchange of an existing annuity or life insurance policy into a Medicaid compliant annuity to convert the cash value or the resource into an income stream. Here is a list of different information that we would recommend that you obtain from a client, whether you're doing pre-crisis or crisis planning for that individual, just so that you can understand what type of contract or policy the client owns, whether it is a retirement asset or a non-qualified account that your client would own. And then on the pre-crisis side of things with annuities and life insurance, we can transfer ownership into an irrevocable Medicaid trust or consider a 1035 exchange into a Pension Protection Act hybrid long-term care insurance policy. Hybrid policies can be owned by an irrevocable Medicaid trust, which will give the family additional options to trigger the long-term care benefit or choose not to if they're past the 5-year look-back period. And then on the crisis planning side of things, we can consider doing a 1035 exchange into a Medicaid compliant annuity, like I mentioned. If we quickly look at a pre-crisis case scenario, we have Bob, who is 70 years of age and recently retired. Other than having diabetes, Bob is healthy. He has monthly income of $5,000 per month from Social Security and a pension. His assets consist of $600,000 in an investment account and $200,000 in a non-qualified deferred annuity. The original deposit into the annuity was $100,000. It's now worth $200,000. So there's $100,000 of gain or deferred interest that has grown inside the policy. If Bob were to liquidate or withdraw money from the qualified annuity, all of the gain is going to come out first and be considered taxable. So if we want to consider using a Pension Protection Act annuity, we could do a 1035 exchange of the $200,000 annuity into a Pension Protection Act annuity, which would give them around 1.1 million in long-term care coverage, which would mean that he can access the 1.1 million on a tax-free basis because it is an annuity that complies with the Pension Protection Act, which would give him around 11 years of long-term care coverage at $8,300 per month. This policy can be used to help pay for care in the home, assisted living, or in a skilled nursing facility. So by using a Pension Protection Act annuity, we were able to do a tax-free exchange of the $200,000 and obtain 5.5 times leveraging for long-term care purposes, creating around $8,300 a month to be able to pay for care. If long-term care is never needed, Bob's intended beneficiaries would receive the $200,000 that was put into the policy. So it's not a use it or lose it type of contract. And Bob could either choose to remain in control of the annuity contract, or he could transfer the annuity into an irrevocable Medicaid trust and still have the long-term care benefits available to help pay for care if he chooses to.
Indirectly.
Yes. So if we now look at a crisis case study, I'm going to go through this pretty quickly here. I see we have some questions. So this is Joe and Mary. Joe is the institutionalized spouse. Mary is the community spouse. And the main problematic asset that the couple has is a $250,000 non-qualified or post-tax dollar annuity that is in Mary's name. So there's around $100,000 of deferred gain in this $250,000 annuity. They're trying to obtain immediate Medicaid eligibility for Joe. So we would have to determine how many of the $350,000 in assets we need to spend down and still obtain Medicaid eligibility for Joe in the facility. So Mary's going to be able to keep around $128,000 of assets in her name, which means that we have to spend down or convert around $360,000 of assets into an income stream. So we can eliminate the non-qualified annuity that's in Mary's name by doing a 1035 tax-free exchange into a $250,000 Medicaid compliant annuity. In order to avoid adverse tax consequences, Mary must be the annuity owner. She is the owner right now, and we would also want her to be the owner of the Medicaid compliant contract. And so we could use Mary's life expectancy of 146 months to annuitize the $250,000 non-qualified contract in order to convert this from an asset into an income stream. By using a 1035 exchange to purchase the Medicaid compliant annuity, we were able to achieve immediate Medicaid eligibility for Joe, and we were able to spread out the tax consequences of the $250,000 annuity over the term of the Medicaid compliant annuity. Instead of the client just liquidating the annuity, we did a direct custodian to custodian transfer so that the $100,000 of deferred gain is going to be spread out over the term of the Medicaid compliant contract. Okay, Mark, I'll let you talk a little bit about the non-homestead real estate.
Sure. So non-homestead real estate is any real estate, obviously, that is not someone's home. So this can include a vacation home, a cottage, a condo, any real estate that is not owned, so, or that is not homestead. So in pre-crisis planning, you know, what we said earlier holds true now. What we try to do is get those assets out of our clients' names so that if they need to or want to qualify for Medicaid at a later date, this asset's been removed from their Medicaid estate, if you want to call it that, and it's been removed for 5 years or longer. So pre-crisis planning with real estate's pretty easy. We just need to move it. In crisis planning, you know, illiquid assets like real estate pose a greater challenge simply because of our inability, if you will, to you can't use real estate. Amber would say so. We can't use real estate to purchase a Medicaid compliant annuity. That doesn't work. So illiquid assets such as non-homestead real estate are tricky to deal with. An example of something that can be done at times, if someone's really low on cash, sometimes in some states, if the property is listed for sale, or we're actively trying to sell it and do something with it, that could sometimes make the property unavailable so that the person can qualify for Medicaid at least. And then when the property does sell, then there'll be cash, and then you have to look at some of the techniques and things that we've just talked about to see if there's anything we can do to qualify for Medicaid benefits. But as the slide indicates, the best thing to do with illiquid non-homestead real estate is to plan early and to get it out of your name as quickly as possible.
Okay, great. And then in summary, just touching on some of the things that we talked about, some of the items or the important things to consider when doing planning is to look at the tax status of the account, to know if it is non-qualified or tax qualified, and to also know whether your state counts or considers retirement accounts to be exempt resource. Also consider surrender penalties or early withdrawal charges to get access to an account. And then with a non-qualified annuity with deferred interest or gain, we can consider using a 1035 exchange to offset the deferred gain that would be built up within the contract. And now you're seeing our contact information on the screen here. If you have questions for Mark, feel free to reach out to him through email or phone. As with myself, you're seeing my phone number and email address on the screen here. And Mark, it does look like there is a question here. Somebody asked, is it advisable to transfer a home that is owned jointly with rights of survivorship to the non-institutionalized spouse to avoid a Medicaid lien after the death of the soon-to-be institutionalized spouse?
Yeah, I'll answer that, and I guess it all depends on your state and certain rules that are in place. But generally speaking, you are going to want to transfer the home from joint ownership to the community spouse, so it's in the name of the community spouse alone. In some states, they still may try to attach to the Medicaid spouse's 50%, and may try to put a lien on the home in that instance. Now, one word of caution is that a lien, while it could be put on, cannot be enforced as long as there is a surviving spouse. So if there is a lien, the surviving spouse could sell the real estate, and the lien would have to be removed, and the surviving spouse can receive all of the sale proceeds.
Okay, great. And then we also have a question here about converting an IRA into a Medicaid compliant annuity being a taxable event. So as long as we use either a trustee to trustee transfer or a 60-day rollover, the actual act of transferring the qualified account into a Medicaid compliant annuity is not going to create a taxable event. But since that money has never been taxed before, as the Medicaid compliant annuity makes payments, it will be considered taxable income as the IRA MCA makes payments. So that's something that would help us to, if the annuity is being funded with pre-tax dollars, we would consider how long we're going to structure the IRA MCA when we're setting that up, because you wouldn't want to have a very short time frame on the payout of the IRA MCA, for example, a 6-month payout where the person is going to receive all of the income from the annuity in the same tax year. If you're going to have a very short time frame like that, you would want to just liquidate the IRA. So instead, we would consider stretching out the payments on the IRA MCA, whether it be a 2-year time frame so that the person is taxed over a 3-year period, or even longer, depending on how old the person is and how long we anticipate them actually needing that income, and taking into consideration that the state would have to be named as the beneficiary as well. So I hope that answers your question. I know that we are over on time at this point. If anybody has any follow-up questions, feel free to call or email us. Mark, I want to thank you for your time today and thank everybody for joining us.
And Amber, I'd like to thank you for including me in the presentation, and likewise, I'd like to thank everyone for their time and participating in the webinar. I've enjoyed it. Thank you.
Thank you. Take care, everybody.
Bye-bye.